Well, good morning and welcome back to the Broadcast Retirement Network. I'm Jeff Snyder. This is BRN AM for Friday, December 6th, 2019. Here are our top stories. How do employee benefits and retirement benefits fit in to the California Consumer Privacy Act? And the Supreme Court hears oral arguments for the Intel case. Data privacy and cybersecurity remain top issues, not only in the retirement field, but in industries around the world. California recently took action with the California Consumer Protection Act, or CCPA. But how does it relate to retirement plans and employee benefits? Well, Kevin Walsh, principal with Groom Law Group, is back with us, recently testifying in front of California lawmakers to tell us a little bit more about what he learned. Kevin, thanks so much for joining us on the program this morning.
Jeff, it's always good to be on the show, and I think the West Coast trip is going to give us what we're talking about this week. There's big changes out west with respect to privacy.
Yeah, and that's something that you have talked to this audience about, and myself many times, about privacy, data privacy, and protection. And we have talked about the California Consumer Protection Act, or CCPA, but you and your colleague David Levine, both of you are principals with Groom Law Group, recently testified before some folks in California. Do you want to give us a skinny on that?
We did. So we went out and testified on CCPA, and kind of the big thing here is that we understand the retirement industry is very recognizes the value of privacy. They also recognize that in order to provide benefits, personal information needs to be used. I mean, if we can't find people, we can't get benefits to folks. If we can't kind of know things about those individuals, like who their family members are, how are beneficiaries going to get identified? How are dependents going to be identified? So there was some fear when CCPA came out that, it could have a real big negative impact on benefits. And then we saw proposed regs, and the proposed regs really, they don't do much for benefit plans. They don't recognize that there's this distinction. And why they don't recognize the distinction is because the law itself was amended after the proposed regulations came out. And the amendment really is helpful for employers and for plan service providers because it narrows the scope of their compliance obligations, at least for 2020. So what we were out there doing is David Levine and I, another principal at Groom, we were talking with the regulators out there, and it's really the California State Attorney General and his team about, what they should do because of the amendment that relates to employee benefits, kind of the need for a template model disclosure so that, right now employers and benefit providers are going to be required to provide a notice in advance of collection. And really, the goal is that it's a workable solution so that the benefits don't get interrupted.
And I mean, this is the normal process whenever new regulations are written. There's a period where they get feedback. Right, Kevin? I mean, I'm not telling you anything you don't know, but for the audience's perspective, and this is important because you cannot view the retirement industry or the healthcare industry or any other benefits industry the same as you would, just like a Google or a Facebook. I mean, there are things, to your point, that we need information, not myself, but providers need information in order to deliver the services that they've been contracted for, and they're protecting that data from bad use, but it's still important to collect that information.
Yeah, so it's important that it's a law of general applicability. It's a regulation that's going to apply to all businesses and kind of all areas, and it's really important that they understand kind of the nuance of the benefit space. But yeah, this is typical where you get a proposed regulation, there's an opportunity to suggest comments, and then there's a final regulation.
And Kevin,
we're now waiting for the final regulation.
Yeah, Kevin, I mean, did you feel a level of comfort? I mean, regulators cannot be experts in every field. And I'm sure that when that law was written, that the tech industry was heavily involved, and maybe the financial services industry wasn't as involved, or at least the record keepers, the people that do the service, the financial engines of the world, the advice providers, people that collected, they probably were not as involved. And really the purpose of the law was to protect people from, like, for example, the Equifax breach or some of these other breaches that have occurred. And also people selling data, which we know is a transaction that many organizations are getting involved in.
Yeah, so I think that the underlying purpose of the law in California is to, there's some trepidation on the part of consumers about how their data is being used in terms of targeted advertising. We had the Cambridge Analytica scandal, and just that, there's a lack of awareness of how companies are using data, but there's a sense that they're using it. And out in California, at least, there's a sense that regulators stepping in might be an effective tool to kind of mitigate some of the more icky uses of data that are out there. Now, in the benefit space, we need to make our arguments because there's a risk that we'll get lumped in and they throw out the baby with the bathwater. And we really need data. I mean, the missing participants issue is one that I talk about all the time. But if you can't collect data about individuals, the problem's not going to get better.
And do you think that once this, we've talked about it before, but I want to ask you again, California, this law goes into effect January 1st of 2020. Now, do other states use what California has done? Because states typically, at least at the state level, will kind of follow what others have done. Will other states follow suit? Or do you think that a federal statute could potentially be something that's looked at?
Well, I think other states are looking at what California is doing, but in the federal area, the Senate Commerce Committee had a hearing this week because there's a Democratic proposal and a Republican proposal that have come out in the Senate in the past few weeks. So they had kind of witnesses who were testifying about, where the bills are similar, where they're different, and it looked like what they were trying to do is find a path to compromise.
And we joke about it, but you do talk about missing participants. You're very passionate about that. People need to know where their benefits are. Do you see these two issues really dovetail together? Is there a sense that at the federal level, the Department of Labor, do they think about data in the same way that California is? Obviously, it's a state versus a federal government, but do they think how they work together to collect that information and use it to locate people and align them back with their benefits?
So I think with Congress focused on data and the FTC focused on data, there's so many different federal regulators right now or federal entities working on the data issue that I'm not sure if the Department of Labor adds much value in terms of just weighing in on this issue. I think there'll be a player in the space once things get sorted out. But for now, I think we're at a point where it makes sense to figure out who's going to be the regulator, because it's easy to see a world where we have a patchwork of different states. But even more fearful would be if we have different federal regulators demanding different things.
Last question, Kevin. As it relates to what employers, people who sponsor retirement plans, could be doing, right? I mean, this law becomes effective January 1st. There are organizations, there are requirements that you have to be like either you have to have a revenue of X, you have to, or this or that. But are there things that employers who sponsor these plans should be aware of when they're talking to their service providers, when they're talking to vendors, their payroll providers, or the things that people should at least start to be thinking about?
So I think if you're an employer, whether or not you're subject to the CCPA, it likely makes sense to begin trying to figure out what types of data you're collecting and who you're sharing it with. And it might even make sense to reach out to some of your service providers and ask them how they're using it. That way, if you get an answer that surprises you, it's better to hear that directly rather than waiting for kind of a plaintiff firm to do discovery and then find out that you weren't sure how your plan's data was being used.
And if you're a participant, if you're just a regular person like you and I, maybe you're not in a retirement plan, or even if you are in a retirement plan, something to be aware of, and you should be understanding if you're using a third-party tool or third-party app to track your balances, you should be aware of this law as well and how it could potentially apply.
So if you're a third party, if you're an individual, you're a consumer, you're a participant beneficiary in a plan, I think the important message here is that there are differences between retirement plans and search engines, and it's while it's good to be protective of your information, please continue to share it with plans so that you can get the retirement benefits, because our country's retirement crisis isn't going to go away if it becomes tougher to administer plans.
Yeah, absolutely. Well, Kevin, thanks so much for that update on CCPA, but I want to hold you over because when we come back, the Supreme Court is hearing oral arguments on ERISA cases. Kevin's going to give us an update. Yeah, oh my. The lions, tigers, and bears, oh my. So stick around, Kevin, and you stick around too as well. Stay tuned right here on BRN AM. Imagine a new television network that will make you richer, healthier, and in control of your financial future. This network is for the policewoman in Nashville, Tennessee, the baker in Dubuque, Iowa, the teacher in Lexington, Kentucky. We want to make the idea of savings and retirement culturally relevant. But what do you see as a defining issue of the midterms, especially for the smaller businesses? I mean, they are the lifeblood of the American economy. Featuring exclusive interviews, current affairs, and docuseries. 33 years old, you retired early.
The philosophy is money only matters if it helps you live a life that you love.
But you got to start thinking about retirement as soon as you get in.
The Broadcast Retirement Network will drive very high engagement with premium partnerships. So this isn't retirement and savings for your parents or grandparents. This is for all Americans. And we're going to change the way you think about money. Welcome to the next frontier of retirement and savings. This is BRN, the Broadcast Retirement Network. Welcome back, and now we're going to transition from one important topic, cybersecurity, to another, some of these ERISA cases that are before the Supreme Court. One in particular, oral arguments for the Intel case. Kevin Walsh, principal with Groom Law, still with us. Kevin, thanks so much for sticking around this morning.
Thanks for having me on again. You know, I think we're talking about the court this time, and I don't think we're talking about the Knicks or the Wizards.
Yeah, that's true. We're certainly not talking about the Wizards, and we're not talking about the Knicks. Both are fairly atrocious this year, unfortunately. But let's talk about the Supreme Court, the highest court in the land. They don't often take ERISA cases, but as you have told us in the past, in the last several months, there have been a few ERISA cases, and recently, Kevin, one case in particular has, they've heard oral arguments. So do you mind just giving us the background on that?
Yeah, so the case that has kind of the ERISA literatis world's attention, to the extent there is an ERISA literati, it's Intel versus Salmaya. And it's a case that's before the Supreme Court now. And the fact pattern is that, Intel has had a retirement plan for a while, a 401k plan. And that 401k plan had default investment options. And those default investment options included some alternative investments like hedge funds and private equity funds. And what the plaintiffs are alleging, essentially, is that, they didn't realize that the funds they were in had alternative investments in them. And that those investments had higher fees than kind of a passive fund would have had, which is unsurprising because, one of the things you're paying for with an alternative is management, and management costs money. And that those funds underperformed. So they're saying, there was a breach of fiduciary responsibility. It was imprudent for the plan to have included these things. So essentially, we want to be made whole. So we want to be in the position we would have been if we had invested in something else that we'd understood better. And what's really interesting right now, we're not interesting, and I probably say too many things are interesting, at least according to my colleagues. But what I find
fascinating.
Thank you for coming up with a different word. With this case is that right now what they're arguing over isn't whether it was prudent to have these investment options. They're not arguing about whether or not hedge funds or private equity are good investments inside of a plan. They're not arguing about what ERISA's prudence requires. What they're arguing about is how long they have to bring their lawsuit. So under ERISA, it has this provision that says that if you're a plaintiff, if you're looking to sue your plan, and you have actual knowledge of what you're alleging, you only have 3 years.
Okay.
If you don't have actual knowledge, you've got 6 years from the breach. And what's going on now is Intel is arguing that, we sent these people their notices, we disclosed this repeatedly. If they didn't read the forms, they should have constructive knowledge. So they should be deemed to have knowledge. Or if they don't have knowledge, despite us meeting all of our disclosure requirements, the participant should be considered to have been willfully blind. So really, if you don't read your disclosures, that shouldn't get you an extra 3 years. Now, the plaintiffs are arguing, well, ERISA, unlike other statutes, says actual knowledge. And actual knowledge doesn't mean I've got an envelope on my floor that says something. It means not only have I read it, but I also understand it. And so oral arguments were at the court on Wednesday. And what was really interesting was that there was kind of a textual thread throughout this, which was, the justices were kind of concerned that if they interpret actual knowledge to mean something other than having read it and understood it, that, this could have an impact in other laws. So there's a lot of criminal laws that require actual knowledge. So I was kind of surprised by that line of argument. Also kind of humorous was that Justices Ginsburg and Gorsuch both said that they don't read their ERISA disclosures, which working with plan sponsors is kind of frustrating, because if they're going to spend all the money and take all the time to get these disclosures to folks, I think there's a hope that they read them. But so there's some sense that, the plaintiffs might win this. The court could hold that you need to have actual knowledge, which on the one hand would mean that in general, if a plaintiff says they're going to get 6 years instead of 3, which could be kind of a big expansion of statute of limitations. On the other hand, if the court has to look at each plaintiff and say, you want to join this class, did you read your notice? Did you read your notice? Did you read your notice? Actual knowledge could become something where class certification could become a little bit tougher, or it could be a factual dispute that you might need to go further into through the litigation process before a class can be certified, and perhaps that could be a good thing for defendants. Really, the arguments were exciting yesterday. The justices, I think they recognize that whichever way they decide this case, there's going to be consequences, and it's going to have an impact on kind of disclosures, statute of limitations, and class certification.
And certainly, but from the non-lawyer, the layperson like myself, I'm thinking two things that we have talked about both here and on the podcast. One, e-delivery. Okay, so I'm just, not that these are tied directly to the case, but it just makes me think about e-delivery, and the justices say they don't read their federal thrift savings disclosures, which, it makes a lot of sense. A lot of people don't read the disclosures, but we've talked about e-delivery, and then what is actual knowledge? We're actually talking about financial literacy in a way that, you have to understand what you're reading. And I can tell you, Kevin, and I consider myself, pretty reasonably intelligent. I read things, and first of all, I have to read them a couple times, but I think it's really hard to understand some basic financial concepts just by reading a 1 or 2 or even an 8-page disclosure. Really tough to do in the course of, day-to-day living.
Yeah, I think those are accurate. Those are pretty good observations. One thing that worries me is that what this could lead to is it could lead plan sponsors and plan fiduciaries to try to put in products that are easier to understand in their plans, rather than kind of products that might be more complicated, but that could generate better retirement outcomes. Yeah,
and I think there are a lot of people waiting on bated breath to see the result of this, because we have talked about on this program with alternative investments that you mentioned, private equity, hedge funds, et cetera. There is a movement in the Securities and Exchange Commission for Chairman Clayton to look at the non-accredited investor rule to see if that should be changed to help allow some of these investments. Because I think the argument can be made from a performance perspective that you need some of these non-traditional asset classes in order to get return. But again, coming back to what does the average person, even the person who thinks they're very sophisticated may not be really sophisticated and understand the basics here. So the implications here are very broad, and as well as deep.
Yeah, in a post-Pension Protection Act world where we have a lot of people defaulted into target date funds, right now there's been a big movement to modernize target date funds, and they could either end up in annuity or they could include alternatives in them. But one thing with these kind of set them and forget them products is that if we're going to design them to better get the average participant who's not paying any attention to a good outcome, the products themselves tend to get more complicated. Yeah. So if the Supreme Court comes out and says that there's a longer statute of limitations period if you include products that are more complicated, even if they're better products, that might be a force that kind of weighs against this trend.
Yeah, absolutely. Well, I guess more to come. Kevin, thank you so much for joining us. I know it's not easy taking a long flight and then jumping on the network. We certainly appreciate it. Enjoy the rest of your week and weekend, and we'll talk to you again soon.
Thanks for having me on. And one last thing is that oral arguments are not always indicative of outcomes of cases. So just because I think it's leaning one way, it could very easily go the other way.
That's fine. Well, that disclaimer, everyone heard that disclaimer. We're not going to hold you accountable. It's just an opinion and not a legal one. Kevin Walsh, always a pleasure talking with you. Have a great night, great weekend, and we'll talk to you soon.
Thanks, Jeff. Have a great week.
And that wraps up this episode of BRN AM. Hey, have a financial topic or someone of interest that you think we should interview? Drop us a line. And don't forget, for all the news in retirement markets, technology, personal finance, so much more, check out today's edition of The Morning Pulse. We'll be right back at it again tomorrow for our weekly look back episode, BRN Weekly. So until then, I'm Jeff Snyder. Keep on saving, and don't forget, roll with the changes.
Waiting here for you to take and drink of. But if you're tired of the same